Singakonfirm mkazi bangena baka Treasury National.
Sawona sihlalo. Ngisaba fonela khona into engimbonayo ngenile la uRahati.
Awurahati ngicela nami ngiyambona uRahati.
Abanye ngisabathinta abakamphendula.
I can end this morning. Let me find them for you. Not to worry.
Please
Okay,
do that
so-
on our so
Okay.
it's gonna be easy. Okay.
All right. Thank you.
Because we'll start with Fanny Mlefe and followed by Leander Peterson. So if Rahati was Susan Angelo, singaba all right. I-office likanzwakele bencube likhona kodwa ke bas manje
Sihlalo ngikhuluma nabo manje bayangena. Thank you.
semlindelo MC ngoba uzongena ke ngeqedwe la lenge. We have 2 minutes. Umshaza ngamboni naye. Thanks, Rahata. So you wanted to confirm that Leanne Peterson is in the meeting?
Yes, she's in the meeting together with Ms. Mashabane. We're still trying to get hold of the CPO, but that shouldn't hold us back. In my case, I have to step off at 11 because I have an interview at 11.
Oh, it's fine. As long as you are saying that comfortable, that will proceed. So Ms. Leanne will start.
All right, thank you.
Are you saying that? No, not now. I'm checking that she'll be able to start in the absence of CPO.
Yes, she will. Yes, she will. She's online. She just needs to confirm if she can start. Leander?
Good morning, colleagues. Morning, Chair. Yes, Mr. Fani is joining. He was just finishing off another meeting, but when it's time for our presentation, we'll be happy to continue, Chair. Thank you.
Okay, great stuff. Thank you so much. Let us greet everyone in the meeting. So just for the record, let me just appear so that I'll ask when we do the introduction that we just appear on the screen so that we confirm that it's not a robot talking or there's no one held at ransom. Duma SA, the chair of chairs in our legislature, we are in charge of ensuring that this meeting proceed nicely. You are all welcome into this platform, and we hope it's going to be a productive meeting productive in a sense that it is just going to yield some positive fruit. Not that this issue of provincial policy or the outcome of Concord is progressive on its own, but the meeting should bear some nice fruit that will be palatable in our mouth. Let us go to attendance. Kazi, please take us through on the apologies. We're told the Deputy Speaker has just given us an apology. He's not going to join us. We're told Linda Madlala and Honorable Linda Madlala, the Chair of Human Settlements, won't join us as well. And Honorable K. Nkosi, the Chair of Finance, won't join us. Those are the only apologies that we have. Are there any other apologies, Mkazi, so that we proceed nicely?
Thank you, Chairperson. No, Chair, these are the only 3 apologies we have received today. Thank you.
Your screen is blank. We're not sure whether we're talking to the robot, and we've already requested that at the right time, everyone should just appear briefly on the screen before we proceed. Please do the honors for you. You are at work. Thank you so much. Thank you. Let's proceed. Let us greet officially. Angus? Let us greet officially our Chief Whip, Honorable S. Zongo. Usholozi siyabonga kakhulu mfowethu for being part of this meeting. The Deputy Chair of Chairs, Honorable Zongo, our midst. Let us also greet the Honorable Chair of Appropriations, Honorable Teles S. Teles siyabingelela kakhulu Sheng. MEC LOGB, greetings. Let us also greet the staff, admin staff from National Treasury in our midst so that we start our process. Can I just confirm while appearing with this substantial while we are introducing, if you can just briefly appear. So those you can do the honors. The Chief Whip.
Yes, good morning, Chair. Yeah, Chair, I'm here. I request that I don't open the camera because of of this particular day, you know.
Oh, I know, it's okay. Honorable, let me say, Ngube, are you affected of the particular day as well? Shenge?
Thank you, Honorable Chair. Good morning, honorable members and everybody on the platform. Thank you very much.
Thank you so much. Shenge. Let us start our meeting, colleagues, so that we fast track almost all these things. We agree that we want to be prompt with time so that we outline all the matters that are strategic. And we've been joined by almost majority of the chairs in the meeting. The purpose of today's meeting, as you are acutely aware, honorable members, that there was a Concord decision which 5 judges, 9-5, said this decision should be taken in this direction, and 4 had a different idea, and the appeal is held on course at that particular time. But the main thrust of this was the court dealing with Preferential Procurement Regulation 2017 promulgated by the Minister of Finance on the 20th of January 2017 under Section 5 of the Provincial Police Framework Act of 5 of 2000. The Act in turn was contemplated by Section 217 of the Constitution. We're told that the rationale of the SCA judgment was that the regulations contemplated a preliminary qualification of tenders without consideration of the tender. This was ultra vires, the Act which contemplated a consideration of all acceptable tenders, a point formula which had built into a point of BE tenders. So we just want a clarity so that the call is made and understood, because as far as we understood from the 12th of February, this had an implication and it bears some things on those. And fortunately, in the province, COCTA had made an undertaking of seeking a legal advice of what is the implication. As we are all aware that the circular that comes from Treasury, and in particular, Dr. Mahajane, the DG, spoke at length, and to some of us, there was a confusion which might derail the process, and we understand the outlook of what is currently happening in South Africa. PT in March, which is the final month before we start the new financial year, a lot has happened in the province of KwaZulu-Natal. I think we're all aware that we're coming from COVID-19, so we don't want anything that might jeopardize the chances of the spending pattern in the province. And we are quite aware already. Official ESCOM said they are not going to be binded by this process. They will proceed, ensuring that they do advertise. And you might clarify if you know, we had already the Western Cape province has resolved that they will proceed with the tendering process, but taking out the section which deals with preferential policy, which we're all aware that it served them well because they've been wanting to prejudice Africans, blacks in particular, in this process. So this is the reason behind for this meeting. Just want to get clarity because chairperson is the committee that deals deliberately with the issue of oversight. They are the one who must ensure that there is an accountability from the executive. So they must just get that clarity. So that's why we invited these stakeholders to take us through. So if I don't know whether we said Fanny will start or Ms. Leanne, we are comfortable from your side, National Treasurer. Mr. Fanny Mulefe told is an acting chief procurement officer. We've invited officially the DG. Unfortunately, the DG was committed for today, then he had to send this delegation. And Ms. Leander Peterson, who is the Chief Procurement Officer, will also just give us their briefing. So in that order, they could start and just take us through. Just make sure that you also accommodate that you have a discussion. Thank you so much. May I proceed?
Good morning, Committee Chair, and good morning, members of the Legislature. My name is Molefe Isaac Fani. I'm the Acting Chief Procurement Officer, National Treasury. DG Dondo Mkhashane requested that I attend the meeting on his behalf. He's committed in other matters, as noted by the committee chair. Chair, yes, we started off the year in February on a very not so comfortable note as National Treasury and as a country with regards to the judgment from the Constitutional Court that declared the Public Preferential Policy Framework Act regulations as invalid. This matter comes from quite a few years back, where the Supreme Court of Appeals has looked at just a few of the regulations and declared them invalid. But the Constitutional Court verdict or judgment came as a surprise to us by declaring the whole suite of regulations as invalid. I'm going to allow Ms. Leander Peterson to give a technical background on the matter so that we can have a conversation at the end of her presentation. Ms. Peterson, if you may.
Yes, you may proceed. You are more than welcome. Recognize you can proceed, Ms. Peterson.
Thank you, Chair, and good morning, colleagues, and all protocol observed. I just thought I'll turn on the camera for a few minutes, but you have seen me now. I'm not a robot, so I think I can. Oh, I'm not sure. Sorry, have I turned on the camera?
Yes, you did for 2 seconds, so it's fine. You may proceed. You have seen
Okay.
me. Thank you so much.
Thank you, colleagues. Thank you, Chair. Let me just start sharing the presentation. Let's see. Is it audible? Is it visible, Chair?
It's appearing right now. It has just entered, and we've been waiting for this presentation, but it's fine. Yes, it will be shared later. Yes, you may proceed.
Yes, unfortunately, we only had got to hear about the meeting quite late, so unfortunately, but I will share it with the colleagues subsequent to the presentation. In fact, I'll do that. Sorry. As the Chair said, I think it was important for us to get that brief introduction from the Chair, so that it at least enabled us to get an understanding of the direction that we should go in terms of the presentation. I think, as the Chair correctly said, we all have heard that there was this judgment that was handed down on the 16th of February. But if the meeting will just allow me to take a few steps back, the issue arose in 2018, I believe it was, when Agribusiness had taken the Minister of Finance to court when the regulations, the preferential procurement regulations, introduced particularly two new provisions relating to pre-qualification of tenders and the pre-qualification as a preferential procurement and subcontracting as a condition of tender. Now, I think it's important to state that even before the regulations, before these two new provisions, there was a provision for a pre-qualification criterion in the form of local production and content, but this was not challenged previously. And yet, and even functionality, if you look at it, the way it is applied, it's an antecedent, it's a step that takes place before you have to evaluate tenders. And yet that was not challenged. And when Agribusiness took the Minister of Finance to court, the judge of the High Court dismissed that case and indicated that in one of his remarks, he spoke about the fact that he doesn't, this challenge is technically a challenge that relates to, it's not about the fact that those particular regulations are necessarily outside the scope of the Act, but just that the application thereof might not have favored the members of Agribusiness. And so the judge was quite vocal in his feelings on this issue. And then the matter was then taken to the Supreme Court of Appeal. And there, the Supreme Court of Appeal found specifically that provisions 3B, 4, and 9 were unlawful. But because they said that the entire set of regulations were interconnected, they then declared the entire set invalid. And it was then, but the declaration of invalidity was suspended for 12 months to give the Minister of Finance a chance to what they held to be, to correct the unlawful regulations. But the Minister of Finance then took that decision on appeal to the Constitutional Court. And it's this judgment now that has caused, a bit of confusion in the space. But what the Constitutional Court held, as the Chair correctly indicated, it was a split decision, a 4-5 split. But if you read the judgment, you'll see that the minority judgment set out very nicely what they believed to be the purpose of the regulations, etc., and how they believed that the regulations were not unconstitutional. And the majority judgment, although they declared the entire set of regulations invalid, their reasoning differed from that of the Supreme Court of Appeal. What the Constitutional Court said was not that Regulation 4 and 9 were unlawful. What they said is, and if you look at paragraph 116, they say that happily, both the minority and the majority judgment, and indeed even the minister, understand the impugned regulations to be doing what is required in section 2172 of the Constitution. But the only bone of contention and where they departed from the minority judgment was on the basis that they said that the minister was going too far in that it wasn't his place to make those regulations because of the fact that section 2.1 of the Preferential Procurement Policy Framework Act, the PPPFA, says that an organ of state must determine its preferential procurement policy and implement it in accordance with the framework that is set out in section 2.1. And so this is the difficulty And so this is why they're saying the minister made regulations that an organ of state should have included those provisions in the policy. So not that the content of what the minister did was wrong, but that the person who did it, he wasn't supposed to do it. It should have been done in the organ of state. So that's a very distinct difference, that the highest court of the land has found that those provisions are not unconstitutional. And so but the difficulty now that came in with that judgment was that it pronounced the regulations as being invalid, but it didn't say anything about the suspension of the invalidity. And that in itself wouldn't necessarily have been a problem. But where the problem came in was that in the minority judgment, there was a footnote 28, that says that the period of suspension expired on the 2nd of November 2021. And that footnote is what is in conflict with another section of the law. So Section 18 of the Superior Courts Act provides that when there's an appeal that has been launched, so that launching of that appeal would suspend whatever judgment was made by the lower court. And if the higher court, in this case the Constitutional Court, has to then uphold the appeal, then obviously there's a new judgment that's given. But if they dismiss the appeal, it then means that that order will recommence. So in this case, that suspension of invalidity that order was suspended when the minister launched the appeal. And so ordinarily in law, when the Constitutional Court handed down the judgment, then the position in law would be that that order now is no longer suspended. That suspensive period would now recommence. So whatever was left of the 12 months would now continue to run from the 16th of February. That would ordinarily be the position. If you were to generally speak to any legal person, they would tell you that. The problem that came in was the footnote that now caused that confusion. And the problem is, because there's case law on both sides. There's case law that says if there's something in a judgment that is wrong, then there's one set of case law, both Supreme Court of Appeal case law, that says you then continue as though that wrong position is not there. So you almost ignore the wrong position because you know that that position differs from what the law says. You continue as though it's not there. But there's other case law that says, no, you can't ignore that. You have to actually go to the court and get the court to set aside that wrong position. And so this is why the minister has now, because there's this legal uncertainty, this is why the minister has on an urgent basis sought confirmation from the ConCourt that the invalidity of the 2017 regulations has been and continues to be suspended. And so at least with that clarity, there can then be certainty in the space. So it is on that basis that the communication from National Treasury was issued on the 25th of February, basically to indicate to institutions that tenders that were advertised before the 16th of February, the advice from Treasury would be you can continue to finalize those tenders using the 2017 regulations. But tenders that were advertised on or after the 16th of February, the advice was rather hold them in abeyance if you can. So remember, it wasn't instructional, so it wasn't binding in nature. It was just saying there is this uncertainty in the space. So if institutions can hold off, it might be more prudent that they actually do that so that they don't find themselves with these unnecessary court challenges, perhaps, or even audit findings. And then the advice went on to say, and no new tenders should be advertised until that clarity has been provided from the Constitutional Court. But as I think the chair indicated as well, I think when that happened, institutions were thrown into a bit of a flat spin and were then constantly trying to check up what is the position now, what should we do, does that mean tenders are suspended and government procurement is halted, and that is why there was the follow-up communication to say no, this is just advice saying this is the position, but obviously institutions are still at liberty to determine their way forward based on their strategic imperatives and their procurement realities and current realities. So the advice then on the 3rd of March went on to explain why there is this sort of confusion in the space, in the sense that even if an institution has its own policy, as the PPPFA says, that policy still has to be implemented in line with the framework. And in the Act, it talks to procurement thresholds, your 80-20 and your 90-10 preference point system, which must take place within a threshold that has been prescribed. And that prescribed in the Act is defined as prescribed by regulation. So in the absence of those threshold amounts being prescribed by regulation, and in the absence in 2.1c, it also talks about formula. So in the absence of that evaluation formula now being prescribed, an institution cannot prescribe their own thresholds in their policy, and they cannot prescribe the formula that they will be using to evaluate. And therefore, even in quotations, even if there's a quotation for 50,000 or 100,000 or a tender for 30 million, in the absence of the threshold being prescribed and the formula being prescribed, that institution would have difficulty then advertising when the regulations that it would have used to advertise that have been declared invalid. And so that is why then the communication also went on to say, but in understanding that institutions can't simply just stop procurement, there's also then the ability to utilize Section 3 of the Act, the PPPFA. In that Section 3C, Section 3 provides for exemptions that the minister may, on request, exempt an organ of state, but Section 3C talks specifically to the issue then of being exempted because it would be in the interests, in the public interest. There's only 3 bases upon which an institution can ask for an exemption, either because the suppliers are international suppliers, or it's in the interest of national security, or it's in the public interest. And 3C was then deemed to be the most relevant provision because it would not be in the public interest for tenders to be halted. It would not be in the public interest for service delivery not to continue. And so, in fact, when this was being discussed, there was an idea that was, sort of tabled that can the minister not maybe give a blanket exemption? But then because the law says the minister may on request exempt an organ of state, it then had to be an organ of state coming forward and requesting that. And in fact, I think as the chair also correctly said, some institutions have said, well, we're not even going to make use of the exemption request route because we believe that the Constitutional Court in any case will come back and confirm that the 12 months or the remaining period of the 12 months is still in operation because of Section 18 of the Superior Courts Act. And so we're going to take our chances and we will deal with whatever legal challenges come our way type of thing. Or if, and we don't believe there'll be any audit findings because the Constitutional Court will come back and say that. So that is the approach that some institutions are taking. So therefore, in any case, it wouldn't be possible to just simply give everybody a blanket exemption. And like I said, but first and foremost, the law doesn't even allow it. So with that as background, then the minister also then filed those papers seeking the Constitutional Court's clarity. They were filed on Friday, the 4th of March. And I believe this Friday, the 25th of March, was the last day as well for, any other papers to be filed and heads of argument. Because already, even this application seeking clarity has already been challenged. One would has been opposed, and one would almost imagine that nobody would want to oppose an application that's seeking for clarity. But we are living in a litigious environment, and indeed this application has been opposed, and therefore now there were replying affidavits and answering affidavits and heads of argument that had to be filed. And so the 25th of March was the date when that all had to be done. And so whilst we cannot know upfront when the date will be set down for hearing, but the consolation is that at least there is movement. And so hopefully this will happen fairly soon. And so colleagues, so that was really the essence of why those two sets of communication were issued. Subsequent to that as well, there's also been posted on the website just a communication indicating what has happened to date, explaining why things had to be done. And then, of course, while that was happening simultaneously in that communication was also then organs of state were also notified that draft regulations were at the same time being developed for publishing for public comment in line with what the Constitutional Court has found. And so this is also why I think it would be important for us then, with that as background, to also then understand what led to the regulations taking the shape that they have done, the draft regulations now for 2022. So as I said, obviously the regulations then, there are basic requirements and provisions that the regulations had to include. The one being what is required in terms of the Act in section 2(1)(b) and C, namely the threshold amounts in which the 80-20 and 90-10 preference point systems must be utilized, and then as well as the formula that must be applied. But then also section 5 of the Act of the PPPFA also authorizes the minister to make regulations regarding any matter that may be necessary or expedient in order to achieve the objects of the Act. And this term necessary and the term expedient was the essence on which even the Constitutional Court judgment turned. So you find that the minority judgment said that it was necessary and indeed even expedient for the minister to make the regulations that he did, given that transformation and empowerment and redressing the imbalances of the past is necessary, and procurement is an opportunity for that to be utilized as a lever. The majority judgment said, even though all of those things are necessary, it wasn't necessary or expedient for the minister to do it. In fact, what the Constitutional Court said was, if the minister found that institutions are not doing what they're supposed to do, it wasn't his place to aggregate to himself that responsibility. So the court was saying what the minister should have done was then find other legally cognizable means to achieve what needed to be achieved. So maybe lobbying his counterparts to say, colleagues, you speak to your departments and to your institutions and so on, and get them to utilize the provisions, to utilize the authority that they've been given to provide for transformation imperatives and redress imperatives in their policies. But it wasn't his place to take over that policy determining role from the institution. So it's quite interesting, that term. So even now, with the new regulations, we had to look at, okay, as far as it is within the power of the minister, what would then be considered to be necessary or expedient, learning from what the Constitutional Court has said. And so when we look at the draft regulations, you'll see then that there is provision for those threshold amounts, there is provision for the formula, and then there's certain provisions that were in the 2017 regulations, which have still been retained, which are regarded as necessary, but there are others which have been removed because those are provisions that can then be contained in the procurement policies that are determined by organs of state. So they've been omitted from this set of regulations because they are things that can actually be incorporated by an organ of state in their policy. So let's quickly go to that then. And so if you look, and I think this omission seems to have created a lot of, of speculation and talk in the space, because there's been the reference to the use of broad-based Black economic Black economic empowerment status as a specified goal for allocating preferential points has been omitted. Now, immediately people think when that is gone, transformation has been removed. There's no longer, we're going backwards, etc. But if we look at what Section 2.1 requires an organ of state to do, it says an organ of state must determine its own preferential procurement policy and implement it within a framework described in the Act. And Section 2.1d, which is a part of that framework, because the framework is contained in Section 2.1. And 2.1d of the Act requires an organ of state to include specific goals in its policy. And according to Section 2.1e of that Act, an organ of state must, in the invitation to submit a tender, clearly specify the specific goals for which a point may be awarded. And when we look at what 2.1d says, it talks to then looking at redress in terms of race, gender, and persons with disabilities. And then it also in 2.1d Roman numeral 2 talks about the goals of the Reconstruction and Development Program. And so if we look there, it then says, and then an organ of state must state in the tender documents those specific goals for which a point may be awarded. So if we now just utilize a broad-based Black economic empowerment status certificate, that means that organs of state don't have the opportunity then to choose which specific goals they want to allocate. So for example, in a tender, they might want to say, for this tender, we want to allocate 18 of the 20 points maybe to persons who were previously disadvantaged by unfair discrimination. And we want to then allocate 2 points maybe to a tender that is providing for manufacturing capability within the country, for example. So the discretion is then left to the organ of state based on its strategy, based on the market in which it operates, based on the empowerment that has taken place there. So an institution might say, female-owned enterprises are really struggling in this area. And so we're going to focus a lot of the preferential points, the specific goals on providing for that category of person. So it's the opportunity is now once again given to organs of state to utilize that, as opposed to saying where even well-established white-owned companies can be a BEE status level 1. And if we look at the Constitution talks to providing for categories of preference in the allocation of contracts, and it also talks to protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. So, but sometimes what happens is in the utilization of your broad-based Black Economic Empowerment Act, enterprises that are still owned by well-established white-owned companies are now maybe getting your 20 points and your 10 points, and yet those enterprises have not been disadvantaged by unfair discrimination. So this, looking at what is provided for in the Act, you see that there's this direct line of sight to the Constitution. Yes, make no mistake, we are not saying that the PPPFA is perfect. I think there's a lot of shortcomings which are seeking to be addressed in the new procurement bill in the Chapter 4 that deals with that. But in the meantime, I think what made things worse was by trying to align to the extent that we lost sight of what should have been what the Constitution required. And then also to further support the reason for the removal of your BEE status in your preferential legislation, we see that there is a BEE Act that already exists, and Section 10 of that Act also provides that every organ of state and public entity must consider, and as far as reasonably possible, apply any relevant codes of good practice issued in terms of the Broad-Based Black Economic Empowerment Act in developing and implementing a preferential procurement policy. So even there's recognition that an organ of state needs to look at those provisions, and that's in terms of that legislation. So therefore, if we look at all of that, it can then be argued that by introducing BBBEE in the preferential procurement regulations could then be deemed as overreach by the minister. And the application of the BBBEE Act by organs of state, coupled with the requirements for organs of state to determine their own specific goals for each tender, then suggests that BEE, as the Broad-Based Black Economic Empowerment Act, as it was applied in the 2017 and 2011 regulations, would be an overreach if we include them in these regulations. And then the next one that has been omitted is the provision providing for local production and content. Again, if you look at what the Act provides for, we can see that this provision was outside the scope of the Act and the Minister's regulation-making authority, because the framework, again, does not provide for local production and content per se, but refers rather, as I mentioned earlier, to implementing the programs of the RDP and provides for points to be awarded for specific goals. So it doesn't provide for local production and content to be used as a disqualification criterion. So instead, what institutions can then do is to look at that document, and they can then determine which of those specific programs of the RDP would they like to then incorporate in their policies, and then utilize that to allocate points. And that document, for ease of reference, we've just indicated the link in the presentation. And then also the provision for functionality has been omitted. Again, this is not because functionality is not important. We acknowledge that an institution would find it very difficult to choose a bidder if they didn't know whether or not that bidder has the ability and capability to carry out the work. However, this provision for functionality is not something that finds itself under preferential. It's not a preferential procurement construct. It's a construct of the broader SCM prescript. So again, if I can quickly just go back to the Constitution, if we look at Section 2171, it talks about an organ of state in the national, provincial, and local sphere of government, when contracting for goods or services, must do so in accordance with a system that's fair, equitable, transparent, competitive, cost-effective. And then 2172 talks about, notwithstanding that, there's still then this provision for redress that it talks to. And then it says in 2173 that national legislation must provide a framework within which the policy referred to in 2172 may be implemented. So when we look at it, there was almost now this division in the way the legislation then unfolded. So you'll find that in the PFMA and MFMA, the focus has been on Section 2171, but then it's the triple PFA that looks at 2172 and 3. And so this is why even issues of functionality, how do you determine who is the person with whom you're going to contract in that fair, equitable, transparent, competitive, cost-effective way? That is then, so issues of functionality fall under that. So they should not really have been something that are in the triple PFA necessarily, but they can then form part of the policy of an institution, or even then be prescribed in terms of other legislation. And of course, I know in Parliament and so on, they have a legislation similar to the PFMA, but it's not the PFMA. It's managed differently. So, but it's those pieces of legislation that talk to your functionality, and it's your triple PFA that talks specifically preference and specific goals. And then, of course, even your MFMA and so on. Regulations can be amended if need be to bring that in, or they can even be brought in under the policies of the institutions. And then if we look at your subcontracting after the award and your cancellation of tenders, again, these are important provisions that should be provided for, but just not within the preferential procurement scope. They are outside of the scope of that Act. And as I said in the previous one, similarly to functionality, they can be accommodated then in broader SCM prescripts. And then, of course, the ones that were the big subject of focus in the court case, the pre-qualification for preferential procurement and subcontracting as a condition of tender. Those have been omitted, again, not because they're unconstitutional, but because the Constitutional Court considered these provisions to be not necessary or expedient to be prescribed by the minister, as it should have been left to the organs of state to determine in their preferential procurement policies. And then issues like the issuance of circulars and guidelines have also been removed, again because a lot of the other provisions have been removed, and specifically even your provisions relating to local production and content. It's then clear that the need to prescribe or to issue circulars has been significantly reduced. And also because organs of state will now be also talking to a lot of these provisions in their policies, there is no longer need to have circulars and guidelines talking to a lot of the issues. However, if it is deemed necessary, maybe that a guideline should be issued or a circular communicating something, they can still be issued without being provided for in regulations, since they're not binding in nature, and they're merely issued to provide guidance to organs of state. And then there is a new provision that the regulations talk to, and that is not regulated in the 2017 regulations. And those are the provisions that propose to prescribe formula to be used when allocating preferential points in your income generating tenders or your disposal and leasing of state asset tenders. So most times it's the state that pays for goods and services, which is a cost to the fiscus. But if you look at the purposeful interpretation of the Act, then you would see that the same principles of awarding points for price and specific goals would also be applicable to your disposal and leasing of state assets and other income generating procurement. And the reason we say this is because this whole issue came before the court again, the Supreme Court of Appeal, in your AXA versus Imperial court case. And here, the legal position was explained quite nicely by the court, and this position then supports the inclusion of this provision in the draft regulations. And then lastly, the section on definitions has also been revised accordingly in line with the aforementioned changes. But also there might be terms that are used in the regulations that have not been defined, but those are then would be ascribed their ordinary meaning. So it was not deemed to be necessary because their ordinary meaning did not change in the context of the regulations. So it was deemed not necessary to to define them. And then just in terms of the way forward, so in the short term then, the comments close on the 11th of April, and they should be submitted to that email address, the comment draft legislation at treasury.gov.za. What we have indicated to institutions as well is that, for example, a province might want to submit a consolidated position. And in that instance, we're saying that's fine. Obviously, we cannot stop institutions from submitting individual comments, but sometimes institutions want to come together and submit a consolidated position. That's also fine. What we usually just say, so in the template, there's a template that's been posted on the website as well, where we say, maybe look at that particular provision, maybe it's section 3 or regulation 3, then indicate maybe the comment that you have, the struggle that you have with the regulation, and maybe a proposed way that you feel that regulation should actually be drafted or worded. So those are just generally what the approach we would be quite comfortable if institutions were to take. And then also the requests for exemption. It's the minister that grants requests for exemption, but he has delegated the communication of that exemption to the CPO. So the letter will come from the acting CPO, but the letter for the exemption, requesting that exemption, should be addressed to the Minister and may be emailed to cpo@treasury.gov.za. And then also, because there have been a lot of queries around the judgment, and an email, a specific mailbox was created to attend to those queries, and that's PPR 2017cc@treasury.gov.za. But you'll see that there's specific mailboxes for specific issues. So the comments on the regulations are sent to a separate one, exemptions are sent to a separate one, and the queries relating to those exemptions should be sent to that CPO address. And this other address that is already flooded with queries is specifically relating to, questions around the judgment, etc. So that's, and then in the short to medium, so also in the short term, the other thing that's happening is then the clarity that the court is, the Constitutional Court needs to provide, and that the Minister is seeking. So that's currently happening as well. The short to medium term then will be, once the comments close, those comments will be reviewed. Some have started trickling in already. So we also are in the process of reviewing that. And then, of course, the revised regulations will need to be drafted and then promulgated for implementation, and where necessary, induction or orientation to organs of state on the new regulations where necessary can take place. And then in the medium to long term, the idea is to finalize Chapter 4 of the bill. This might happen, together with the entire bill, or there's also contemplation and consideration of whether or not it wouldn't be feasible to maybe extract Chapter 4 from the bill and finalize that expeditiously, and then maybe when the rest of the bill is finalized, reintegrate that chapter back into the overarching legislation. So these are options that are being considered to try and ensure that perhaps issues around empowerment and so on don't fall by the wayside. And I think, let me leave it there for now, Chair and colleagues. Thank you very much for your time and attention.
Thank you so much. Thank you so much, Leon, for that presentation. I think it was critical that you take that time. In the interim, please just make sure that you also email to our staff so that it could be shared with the chairpersons. Let us quickly go to the Chair of Appropriation, Honorable Shenge. He has been around in our legislature, currently served as the chair, is the former Deputy Minister of Finance, so is the one who's understanding all the dimensional roles of this, in particular when it comes to the implementation strategy. Before we give Sheng a chance, let us also acknowledge the presence of the chair who deals with defense in the National Assembly, Honorable V. Xaba. Cyril Xaba is amongst us in this meeting. Thank you so much, Nonkos. You'll get a chance when we have to talk. Briefly, Shenge, please take us through so that we are able to also dissect their presentation afterwards.
Thank you, Mtombeni, the chairperson, and let me welcome the presentation and congratulate you for taking this initiative, so that at least as a province there is a common understanding as to what the expectations are. But let me start by defining our interest in the proper implementation of the Act, the PPFA, and the Section 217 of the Constitution. I think our interest as the chairperson of the Standing Committee on Appropriations at National Parliament is that the National Parliament and the provincial legislatures, they appropriate money to the different departments, SOEs, and so on and so forth, agencies. And we expect that money to be spent and be spent according to the laws of the country, but mainly to allow us to deal with the inheritance of poverty, unemployment, and inequality in our country. So from what we are when we look at this, is that come the end of the fiscal year, many departments may be coming and say, no, we couldn't achieve our objectives. We couldn't finish our spending, our budgets, because there was this confusion around how we need to procure goods and services. So I just thought let me explain that interest, and then again make this one upfront that all of us who are involved in the drafting of legislations, I think it's very important that the act should be simple so that it's properly understood. You can see right now that all of us are running health scatter. How about the ordinary people out there? Abantu basemahlabathini, for instance, how do they read this thing? Because this act is not about us who are in legislature, it's about the people that have elected us to this to this responsibility. So I'm just saying that National Treasury, you should note that. In fact, even when you were busy making this presentation, I was even saying that if there's an area that we should be able to start writing these legislations in our languages, in all official languages, this one on procurement, I think is something that we should continue, because this is not about just the lawyers and us who are sitting here. It's about the people of South Africa. But what I will say, I think let's accept even from the presentation that Section 217 of the Constitution still holds, which talks about preferential procurement. 2, the Preferential Procurement Policy Framework Act still holds. So what has been found to be ultra-virus is the Preferential Procurement Regulations of 2017. So the Act, the Constitution and the Act still hold. And based just on that, I don't see I would like to hear what OCPO is saying. Just based on that, there's nothing which says, 1, procurement, which says procurement should stop. 2, there's nothing which says preferential procurement should stop to deal with the injustices of the past. So I think institutions which are rushing now and say, no, then we're going to disregard the BE, I think they're being overzealous. I would like to hear your comment, LCPO, on those statements that I have made. I'm saying this that because before the 2017 regulations, we're still all procuring goods and services. So we need to continue that way because there were no regulations. The regulations are only 2017 regulations that have been declared ultra-virus by the Concord. So again, trying to make the point that we should now be frozen and not do anything because now there's been this finding. But oral members, I think what this says for me, having looked at and again with OCPO, they've made a presentation to us before about the bill. What you'll realize is that the bill is very thin on broad-based black economic empowerment in general. It's very thin. In fact, it relegates that to the regulations again. I think for me, the lesson from here is that let's get the things that want to happen in the legislation, so that you don't leave these things to different interpretations and so on. So I think, Lwandle, one of the things that you really need to do is to ask whoever, even OCPO, to come and present this bill to you, and it would be good that you really make serious inputs on this thing, because if we miss it here, I think we must know that the horse has bolted. PPFA, as it was, if you wanted to see whether it did achieve its objective, the simple answer is no, and it doesn't need rocket science to see that. You must look at the indicators, what is happening to poverty, what is happening to inequality, what is happening to the ownership of wealth of this country. It's getting worse. So it means the PPFA in its own, it really didn't help us, no matter what the good intentions were. So now we've got an opportunity as legislatures to look at this public procurement bill and make sure that learn from what we couldn't achieve with the Preferential Procurement Policy Framework Act of 2000, and make sure that we get those things in the public procurement bill. As I'm saying again, I think I want to underline that if you look at its current form, the bill relegates a lot of these things that are so critical and so central in the transformation of the economy of this country to the regulations. And I think we definitely need to look into that holistically so that we make sure that what we failed to achieve as far as equality and transformation, economic transformation are concerned, we're able to
clearance to go to.
Yeah, what we were able to get those objectives. I think, Honorable Chair, I would leave it at that, and again say it's a good initiative. It should not be an event. Let this be a process until we see the public procurement bill finalized. So, but what I will then say that in a very short statement, I would like to hear what the OCPO is then saying to the KZN as far as what do they do now going forward as far as the procurement is concerned. Thank you very much.
Wow. Thank you so much, Sondia. You've just given us a galvanized strategy. You said you have raised pertinent questions that we are going to raise in any way. Thank you for that clarion call. Shwabata, are you still in our midst? Are we audible on your side?
Yes, Chair. Good morning, and thank you very much for.
Can I grant you 3 minutes and just
yes,
swipe? You are one of the legal framework mind in this body talk.
Thank you very much, Chair. I will not even take your 3 minutes. Thank you very much for allowing me to access the meeting and listen to the presentation. And it's very disturbing developments. And but I agree entirely with the chair, Swiso Telezi, that I think this presents us with an opportunity to recalibrate our position in respect of preferential procurement in the whole country. We had good intentions, but there's very little to show for those intentions that are stated in the legislation and in the regulations. And so I think it grants us a good opportunity to look back and see what we can take from the previous policy positions forward, and then decide on the new things that we think we need to do in order to improve on those policy positions. Chair, thank you so much for the opportunity. I will just leave it to the rest of the colleagues on the platform. Thanks.
Thank you so much. All members, the platform is yours. CPO and team are here just to give us clarity on what will be raised. The DGs mentioned to us yesterday that we are the only province anyway that have requested for this, so you must just understand that it had to be organized in this way. Even the executive one why is saying this is just we've invited our MEC, Treasury. Unfortunately, she's still busy in another meeting, and apparently we can't take her out because in our province, CPO, we are the only province with what is called the tribunal, and she still have to fast track some of those things. And already, I thought when the presentation was done by Miss Leanne, the letter and the spirit, I hope she understands, because from a face value, you might think whoever took us to court had just an idea. No, the reason behind for this is the antithesis of transformation. They just want to make sure, unfortunate at this point in time, because you know at the level of Treasury that you've appropriated more than 2.1 trillion in this financial year. The major beneficiaries of those are the white firms, are the white males who still dominate the industry. And if we are not sharp enough even to challenge this, then we'll have a problem. 11 April is somewhere just around in 2 weeks' time from now. Others will not participate. Honorable members, I'm just prepping the appetite on your side. I'm just enticing your palate just to deal with this matter. I'm looking for hands on your side so that they just respond once and for all. And we are blessed to have these two chairpersons who have just galvanized a strategy for us going forward. The hands, I see the hand of Honorable Dlangamandla Usonjita will be number 1. Can I take another hand? Even the staff or from the administration of legislature, Nerusha and your staff secretary, you are also allowed to raise concern if you want. Honorable Tsele will be number 2. Honorable Manchinga will be number 3. Let us take those hands in the meantime, because you can also shout those who have a disadvantage when it comes to their gadgets if we have not recognized you. So let us take this set. The platform is yours, Dlangamandla.
Thank you very much, Honorable Chair. I'll be brief. I just want to thank you and your team for organizing this presentation, and greetings to the honorable members of Parliament, Honorable Paba and Honorable Telezi. And thanks for the presentation. I think the first thing that it does, because although there is no formal thing, but you are hearing departments wanting to use the excuse already that will not be spending. Well, some are already not, they are already gone now, but the excuse of this judgment is already circulating in our province and to an extent in all our municipalities, in a sense that people are using it as a way of not proceeding with the awarding of tenders, and we know what that do, especially our poor who really deserve the services. So I'm suggesting that this presentation assists us in that sense, in a sense that we are then going to be able to challenge some of the officials who might want to use this court judgments as an excuse of doing what is right by our people, especially the poor. But I think what Honorable Teles was saying is also critical. I think maybe, Chair, with your guidance, we might want to think as a legislature of KZN now, how we respond, whether individually or as a collective, so that by the time the closing date comes, we'll have said something. And I think the legal team in the legislature, we are lucky that the secretary has a legal background as well. They must assist us so that we formulate positions. What we must not do is to allow the pushback for the transformation. I think that's one area that we must not allow it, and we must take this issue very seriously, because I think it gives us as an opportunity to even be aggressive using the law, because we have been, I think the law has been there, but we're being nice, and I think we must tighten up the law that assists this government to transform this country. And I think there is no better opportunity than now that we use the law to even push for transformation to happen and happen faster. Thanks very much, Chair.
Thank you so much, Dlangamandla Mkhulu, for that. Kabatela, the platform is yours. Honorable Zerel.
Thank you so much, Chair, for the opportunity. My apologies. I won't be able to open my video, as you said, on the type of a day it is today. One would like to greet the leadership that is part of the meeting, Honorable Klaba and Honorable Teles, and all honorable members that are on the platform, and colleagues from different departments, including the Secretary of the Legislature. Chair, firstly appreciate the presentation done by Ms. Peterson. I think it's giving clarity for us who are panicking, and as Honorable Sonjita has said, that you were hearing departments now saying that they are halting all tenders, there's no spending and all of that. And I appreciate as well the input that was done by Honorable Telezi and Kaba when they are speaking about simplifying these type of acts, because they sometimes are used not in good faith by officials. My question as well maybe would be for National Treasury on the BEE Commissioner, to say that what are they saying also in this regard? Have they in any way, because I know that we've got a BEE Commission in the country, what has they been their contribution in this, if any, in this thing? Because we know that the people that are challenging this, the minister that have challenged every form of transformation that we're trying to do in the procurement, are people with deep pockets. And these are people who are the very same people that have never even done anything when it comes to BE. They've been trying to find a way not to even pay for anything or give anyone an opportunity. One appreciate the fact that there's the leadership of National Parliament here, because they must also assist us in redrafting some of these laws that we must, as Honorable Sonjita said, to tighten the ship and make sure that we are aggressive in fighting for transformation. We must do more. Thank you very much, Chairperson, for your diligence, for forever being able to find these critical meetings, and you put them together for us so that we can be able to air our views and get more clarity. But I like the point that says this should not be used as an excuse to spend and for people to deliver transformation for our people. I thank you, Chair.
Thank you so much, Kabatela. Mancheng.
Thanks, Chair. Greetings to everyone. I think first and foremost, we must appreciate and acknowledge the platform that has been created, Chair, to get clarity and a better understanding of the Constitutional Court judgment and the expectation and the implementation thereof. I think the two speakers have covered me. The first point in the main that I would want to emphasize is the one that Honorable Sonjita has spoken about, of a formulated position by the KZN legislature, which should be able to reflect on our views. But obviously, it might be even persuaded, understanding that the different political parties, which may also have their different views, maybe we could move with the view that each political party make a submission, which then reflect on what the thinking of the particular political party, which obviously the one that I belong to, the African National Congress, would definitely be pushing for transformation. It's what it fought against apartheid for, and we will continue to insist on such. The second one, Chair, is a bit of a clarity-seeking question from the National Treasury, that I'm of the view that the National Department itself was caught flat-footed about the outcome of the judgment, because the explanation that is being provided to us now, I do not know how far it went in terms of being provided to heads of department and all the relevant parties within whom are operating and guided by the outcomes of the judgment. As you have correctly said, sir, and every other speaker, that already the report that we've been getting from the departments and the head of departments is that over and above that, the letter from the DG was saying, though I have not had an opportunity of having that letter, obviously was not directed to us. It had an indication that was saying that tenders must be halted. It did not spoke on options thereof that says you pursue them, you follow these regulations, which some of them she was explaining that had to do with asking for making a submission, to the minister. Now, as they come to us, it was of more on the basis of the communique that is saying, halt all the tenders. And literally, there is nothing else that can be done on that basis. So I'm just wondering if what is being presented to us, could it be confirmed so that as we then engage again, now empowered with this information, we also get an opportunity to stand our ground to those that are responsible and to those that have indicated to us their understanding of what was there, in particular the communication from the DG saying to them. So that's the first clarity-seeking question in terms of how the communication was done and the explanation to the department. Maybe even if they could also reflect on that letter. Like I said, that chair, it was not directed to us, so I've never had an opportunity of having that letter. Safe to say, it's what we're informed by officials. The second one, which is my question, is there will be a lot of under expenditure which will be based on this constitutional court judgment, and part of what they say as well, it's their fear on the AG should they had decided also to act against, in particular, the directive from the DG. And you know, Chair, that with the new regulations that empowered, that gave more powers to the AG, it caught more officials in a sense where they really move in a direction that says that they fear most on being implicated by the AG and the consequences of the recovery direct from their persona. And as a result, over and above that, I know for a fact that already many departments have said that they'll understand, but on the basis of the outcomes. So my clarity-seeking question is that, is there any mechanism that understanding this crisis, because I would say it's a crisis because it literally put government into a standstill. I know no department, at least in our province, that in between the time the communique was released and probably until any intervention, it was able to operate in terms of the processing of tenders and so forth. So it literally put, especially those that sometimes delay their expenditure, and they're still saying that we're still having 2 months, meaning February and March, to reach the end of financial year. Is there any mechanism, obviously within the regulations and the law, the Treasury will be trying to advance understanding the crisis of the Constitutional Court in dealing with such departments that will be saying, here is our submission, our projections were interrupted, provided they can prove, because it's different from someone, Chair, have not spent from the first quarter, second quarter, and the third quarter, who wants to come on the fourth quarter and justify their failure to spend on the constitutional judgment, vis-a-vis someone whom the expenditure patterns proves that they've been doing very well up until the February Constitutional Court judgment and the communique from the DG. So my question would be, is there an exception or any plan from Treasury, understanding that could be developed or that is already in place in assisting such institutions or departments, so that even ourselves we get to engage them to that level whenever they come to us and making that submission on the basis of their failure to spend. And further make a submission that, can you imagine how many people will be empowered with some of the information that ourselves have received today? And probably as the legislature, the secretary of the legislature could assist in saying, how do we now, as a province, spread this information so that it reaches also the relevant people and they get to understand the concept of it, but including to mobilize the support of ensuring that these submissions that we need to be making are not just the submissions that are made by us, but give the masses an opportunity also on them to be part of us in trying to advance the transformation agenda. Those are my clarity-seeking questions, Chair. Thanks.
Thank you so much, Hlabangani. Comrade Govender, the Chair of COPA.
Thanks, Chairperson. Chairperson, I just wanted to raise one matter. I noticed early on in the presentation, there was a reference made to the issue of local content. And I want to say that, in terms of the regulations that the Department of Trade and Industry had put forward, this issue of local content was very important in looking at transformation of the way in which procurement is done and assisting up and coming enterprises, etc. But what we did find, and we do find, is that provincial government departments, I'm talking about KZN, I can't speak beyond that, do not actually ensure that this is happening. And it's been a finding that has emerged repeatedly in the reports of the Auditor General that provincial government departments are not adhering to local content regulations and requirements. And I'm wondering whether this can be firmed up as well. Thank you.
Thank you so much. That was the last one. Not unless if there's one who want to shout. If that's the case, then let me just advance two matters as well on my own. I think thank you so much for the presentation, CPO and your team. I think one is worried. I've already highlighted the issue of letter and the spirit. I don't think at this point in time, National Treasury understand it how we understand the repercussions. At this point in time, this statement I'm going to utter is unfair towards you, but is more relevant towards the DG and the minister, because the minister has committed that he's going to join us when we do our workshop, or is going to join us in one of our sessions. At this point in time, we don't think, or our feeling is that the National Treasury is being controlled by national technocrats. Technocrats are at the verge of collapsing the transformation. So I've already mentioned the antithesis, but that is why I'm saying that it might sound unfair towards you, but we don't think they are playing their role at this point in time. I think you've heard the argument from these honorable members. Number two, when do you think will be the right time of ensuring that the role that is played by Auditor General and National Treasurer is understood to be ensuring that the transformational agenda is at the fore? Because at this point in time, if you are not aware, people with your team, Auditor General is just seen as this animal that is going to come, which is why Honorable Manchinga, Honorable Charlie was saying that others won't even spend. They will rather compromise service delivery and comply towards not spending money so that they'll look good on the issue of expenditure pattern. So that has been caused by these things. I've already mentioned that if you could just even go the goods and services in almost all provinces. In this financial year, as KwaZulu-Natal, we have appropriated 140 billion. Imagine, because there will be under expenditure from department, imagine what is going to happen as we've got these 12 months. The departments will hold a service delivery or implementation of their budget simply because they won't have a clarion call of judgment. This ultra-various thing, in terms of state of organs, some will be able to articulate because they will be brave enough. But we can't put the issue, this revolution at chance, thinking that those who have balls or who are strong enough will spend, those who are scared will not spend, because it means that the country will be run according to emotions as opposed to Section 217 of the Constitution, which has been compromised, because this ABC is not what is taken. What is critical is two, where they are scared that not unless there is a policy formulation that favors the BE. So if you can just take us through on those matters, we'll be okay. And lastly, you could say, who is opposing the clarity matter in court, if you know, at this point in time, so that we can just get closer towards those processes. The platform is yours, Babu Fan, and your team. I hope Fan is still around. Oh, yes.
Yes, I am still around, Honorable Buthelezi. Thank you very much. I would give it a first go in terms of responding, and Ms. Peterson will fill the gaps with regards to other technical matters that I may have missed. I think I need to make a statement that under National Treasury did not stop procurement of goods and services. What we have clearly indicated in the letter or in the communication that we sent to the organs of state dated the 3rd of March, we have indicated that any matter or any tenders or quotations that were issued prior to the declaration of the regulations as invalid by the Constitutional Court should continue being evaluated and adjudicated. So organs of state should have continued to award those tenders based on the regulations that were valid at the time when they issued the tenders and which are now declared invalid. So that's the position that we have given to the organs of state. What we've then said was that any organ of state that wishes to issue a tender from the 16th of February, which is the date of the declaration of invalidity of the procurement regulations, must come to National Treasury and request an exemption so that they may be able to use the threshold in terms of PPPFA. I just want to indicate that procurement wasn't stopped, and we have meant the office 24/7 to assist on the exemption process. And the exemption that the KZN has put forward is being considered by the minister, and it shall be responded to shortly. If not today, first thing tomorrow morning. What we are also doing at the moment, Honorable Chair, is that we like the presentation has said that Ms. Peterson has done to the committee, is that we are dealing and expediting the process of making sure that the regulations that deal with an exemption, that deal with the threshold, is expedited while we are still awaiting feedback from the Constitutional Court on issues of the 12 months period where we need to fix things. But we are hoping that whichever comes first, we will implement. But from where I'm sitting, I'm bargaining on winning on the 12 months so that we may get our house in order as government in these matters that deal with transformation. Public procurement bill is being expedited at the moment. There are two episodes that naturally halted the process. The minister had considered the public procurement bill for deliberations at NEDLEC, But with the impact of the Constitutional Court ruling, as well as with the Zondo Commission findings that came through in Zondo Commission status of reports, we just wanted to make sure that the public procurement bill is not going to come back from cabinet for us to fix this area. So we are looking at the impact. Should there be no impact, we will proceed. Should there be a major impact, then we will go through the process of stakeholder engagement to ensure that all our stakeholders understand what the impact would be to them, and we can have fresh responses to the public procurement bill to make sure that it covers all elements of government or all the consents from organs of state. If I may, to respond to Honorable Sonjika's question, is that I have spoken to that tenders before the 16th of February were not halted. They should have proceeded. So any organ of state that advertised the tender should have evaluated the tender, and they should have awarded that tender accordingly. So there was no stopping of that happening, because at the time of the tender issuance, the regulations were still valid. I've also spoken to that KZN has done a deviation request or an exemption request. We are considering that. And maybe again, I must just indicate that the public procurement bill's intent, if you look at the objects, among them are the following: that there are too many pieces of legislation confusing organs of state. So public procurement bill would want to take all those pieces of legislation and just come up with one set of rules that government would use. That was one object. And the other object is to look at issues of transformation. And Section 4 of the Public Procurement Bill specifically deals with issues of transformation. This Constitutional Court ruling, through the spanners in the works, we may have to go back to that section and see whether that section's based on the ruling of the Constitutional Court. Currently, will it still pass the test when we are litigated, once that becomes law of Parliament? If I were to respond to Honorable Tele's questions on the BEE Commission, the Constitutional Court ruling has no impact on the Triple BEE or the Triple BEE Act itself. If you look at the regulation that we want to put together now on Triple PFA, which deals with the threshold, we have not taken out the 90-10-80-20, which with 10 giving us the BEE points and 20 giving us the BEE points. So that part is still intact with regards to Triple PFA. So there is no impact in that space. However, we have not had a pronouncement from the BEE Commission, as Honorable Trele has asked, pertaining to the matter. It may be because of the fact that BEE Act, Triple BEE Act is not impacted by the Constitutional Court ruling. If I may proceed to Honorable Mjali's comments and questions. Yeah, I think I have indicated that the letter of the 3rd of March clearly clarifies that procurement hasn't been stopped. However, what it also clarifies is that should organs of state wish to proceed, they should approach the Minister of Finance to seek exemption on the application of the formula. And KZN has indeed approached the Minister for that application. And we are considering it. We are expediting the response thereof. The other issue that was issued was because National Treasury has been clear in its communication that organs of state may proceed evaluating and awarding tenders that were advertised before the 16th of February. That should not have AGSA declaring any of those contracts invalid. But we are having conversations. We should have had conversations with AG last week. Due to other circumstances, we had to defer it to later in this week, where we are going to clarify what the audit terms of reference would be pertaining to this Constitutional Court ruling. It is National Treasury's position that there should not be any audit findings for any tenders that were done correctly in line with the regulations that were applicable before the 16th of February with regards to procurements of goods and services by organs of state. Maybe I need to be practical on one of the issues. Honorable Mjali indicated that there are talks in the corridors, and the CFOs and the SCMs are coming and indicating that as a result of the Constitutional Court ruling, they are unable to do procurement. If you look at, if no tender was issued before the 16th of February, and should the regulations not have been, should the Constitutional Court not have come up with the ruling that it has, and the issues of invalidity of the 2017 PFR regulations was, let's say this, the court said they're giving us 12 months to sort out the regulations. Any organ of states that had not at that time issued any tender to the market would still have had challenges with spending the money that they should have spent in the last quarter of the financial year up to this point. So there should be, if anything at all, very minimal impact with regards to spending in this financial year, particularly after the 16th of February for organs of states. Any organ of state that did not issue a tender before the 16th of February might have not been able to issue it even today if you look at the processes applicable for a tender to be issued. Better still, if the tender was issued, goods and services must be delivered and invoicing should take place. Therefore, we might have not, or we would have not been able to issue any payment prior to goods and services being delivered or invoicing done. What we should guard against is, if this was taken as a marathon to be able to spend money, we may have seen issues of fiscal dumping, and that is absolutely discouraged by all regulations in government, and organs of states that advances that argument that the constitutional ruling has impacted on them doing procurement in this last period from the 16th of February to 31st of March may need to justify to their principles with regards to where were the processes when the ruling was done. But I am saying that from a technical and a practical point of view, but there may be other circumstances that may lead them not to have spent, which are not privy to me at this present moment. If I may move to Honorable Governor, Mrs. Peterson will touch on issues of local production and content in detail from a technical perspective and legislative perspective. Honorable Buthelezi, Chairperson, you also indicated 3 matters. The issue of technocrats, I will have a conversation with DG with regards to that. The issue of AG that needs to understand the transformational agenda. It is our responsibility as National Treasury, having consulted all organs of states, to make sure that the new public procurement bill covers all elements of transformation. AGSA audit us based on what we said are the laws of the country that governs procurement. But there are other teething issues that we have to engage on, such as issues of irregular expenditure and how to treat irregular expenditure moving forward. And those conversations are ongoing, and we shall find finality. We had hoped that we have that conversation before the new financial cycle starts for PFMA cycle and before the MFMA cycle also starts, to make sure that we understand each other on the issues of irregular expenditure. And Mrs. Peterson would touch on who is actually opposing the application. I have not had an opportunity to be informed in that space, if she is informed. Ms. Peterson, if you want to add.
Thank you, Chair. I'm not sure if I should come in now.
Yes, you are recognized. You can come in.
Thank you, Chair. I'm just going to maybe say one or two things, but if the Chair will permit, I'm also here with my colleague, Mrs. Mashabane and Mr. Matibula. So I know that they might want to say one or two things. I know Mrs. Mashabane she's part of, and Mr. Matibula, part of the team, and there's specific areas that they also talk to. And I think in this instance, there's something that Mrs. Mashabane would like to bring in as well. But if I may just answer the Chair's question relating to who is opposing the application, it's actually the very same body that challenged the two regulations in the first place. So it's AfriBusiness, who has now changed their name to Sake Lige, and they are actually opposing because it's an ex parte application, meaning there's no real need to have other people involved. It's just between the minister and the court. But because there were other parties that were involved in the initial challenge, there was an obligation to inform them of the need to seek this clarity, and they then indicated that they then opposed that application. So, and I think the committee has expressed, that there are sometimes other intentions and other agendas, and I think that doesn't necessarily escape the Treasury, but obviously we then deal with it in terms of what the law provides. And like I said, even in the High Court application, the judge that was dealing with that, made some very vocal and scathing remarks, if I may say, in relation to the application, and sort of recognizing that it does not necessarily seem to be a bona fide challenge to the regulations and them being outside of the scope of the Act, but maybe more to advance a different kind of agenda. So thank you for those comments. Just in relation to the BEE Commission, I think as the acting CPO said, they didn't necessarily say anything relating to the Constitutional Court judgment, but very soon after the judgment, of the Supreme Court of Appeal, the BEE Commission actually issued a media release on the 4th of November, where they noted the ruling of the Supreme Court of Appeal, and that they confirm that the ruling has no effect on the BBBEE Act as amended and its requirements. So essentially, they indicated that the objectives of that piece of legislation can still continue, even in light of the regulations having been declared invalid. I must also just say, colleagues, that it was very interesting, and I think one of the committee members also mentioned how people with deep pockets, can do much in the legislation, in the court space, because of it's costly. But I think it's also noteworthy to mention that when this challenge happened, it happened at a time when, in fact, during that time, there were a number of friends of the court that joined in with AfriBusiness to challenge the Minister of Finance. And unfortunately, the minister had to stand alone. It was unfortunate that other government departments didn't join in, or other interest groups. And but thankfully, at the Constitutional Court, the minister, there was friends of the court that joined, and it was the EFF that had actually joined and also put up a very good argument in relation to the judgment. So I think it would have been very important, even for other interested bodies to also join in. Who knows, maybe the 5-4 would have been swayed to 6-3 in favor of the minister. But that being said, I think even as some of the members, the honourable members have said, we need to learn lessons from these things. And I think it's important that we use the opportunities that are presented to us in terms of legislation making opportunities, and even in terms of challenging. Let's rally together as government, and if we understand that the aspirational objectives that government has, let's then, do what we can to advance them. But let me hand over to my colleagues first, if I may, Chair, so that I don't want to, at least the committee must hear another voice, but also just to give my colleagues who are on the team an opportunity to speak to some of these issues. Mrs. Mashabane, through you, Chair, please. Thank you.
Thank you so much, Mr. Mashabane. You can come in. I'm sure Mr. thought Honorable Teles is the one sharing Lina Stulo Vatikopano that Duma. We may proceed.
Thank you, Chair. Honorable members and colleagues, thank you for the opportunity. I will switch off the video so as to proceed. Chair, it's just to what is critical, I think, from also Honorable Buthelezi with regards to the fact that 2017 we survived before 2017. And I think it's important, Chair, to really appreciate it. Yes, we survived because there was 2011. And even before 2011, we survived better because there was 2001. And 2001, Chair, was before the BE component was actually incorporated in the regulations. And the position that the BE Commission took when the BE Commission was very clear that the issue of our regulations being invalid doesn't affect the BE Act and its related piece of legislation. It's actually, it sort of like, it makes sense because we know that in 2006, in December, the Cabinet, when they actually instructed that there must be alignment between the BE Act and FFA, and FFA had to be amended. That was the instruction from Cabinet. And the reason was because the legislations were not appropriately aligned. So we are sitting with the situation where it's a fact that these two are not appropriately aligned. However, when we went to 2011, we then went straight to the regulations and brought in the BE component in it, and sort of like throwing away that which was in 2001, which was very specific in terms of empowerment. And this, Chair, I think, for me, is very close to my heart because we were actually implementing 2001 when you could actually empower direct when we were at eThekwini. We could empower direct, whether you're talking to a black man, you're talking to a woman, you're talking to a youth. There was the way we had policies to do the empowerment. And immediately the BE component came in, the faces changed because all of a sudden, I'll have to prove that I'm black by going and getting a certificate. And I don't think that was the intention. Because when we look at the empowerment and transformation, we are really thinking hard within Treasury, and that's what we need when we engage, Chair, especially from the legislatures and all interested parties, that we really take a step back and really ask ourselves, who are we really empowering? And from the BE perspective, yes, we are empowering mostly big companies. And when you find an element of an empowered individual, you find this black person that could have been 100% if we had a line of sight to the Constitution, now having only 25% because the BE scorecard has got one element of a black person. So we're actually saying, let's go back and look, these two are not aligned. When we align them, how do we align them in such a way that the broad-based element is not lost and not streamlined to fewer huge companies that who is there, or we can ring fence, for example, for grass cutting, and have people who are sitting in Mlazi to be able to do their grass cutting without them have to spend about thousands to get a certificate as proof that they can be part of the tender process. So there were those elements that were brought in, and the purpose, Chair, is because, the reason, Chair, is because these two pieces of legislation have got different mandate owners and with different intentions. So the preferential procurement, we need to be very clear that is to make sure that preference goes at previously disadvantage. When you're bringing transformation, how do you bring it in such that the original intention is not lost? And you must say that when you move from 2001, 2011, we lost it. We took a different turn in the name of transformation. And when you are bringing in BE once again, let's make sure that at the act level is clear, the alignment is understood before we go to the regulation. So it is that, Chair, that is very much critical. And we are discussing it in Chair. But let's stick within our mandate of making sure that we preference appropriately and empower institutions based on the mandate of the Constitution to empower appropriately and not be confused with the BE that comes in and then messes up the masses. And just to close chapter 4, we could actually report on how many have been empowered. Very clear, because it was direct. With the scorecard, at this point, we don't even know how many. It's just the nature of the way it is crafted. But at the same time, we say we've got millions that have gone to BEs. And who exactly, in terms of being Black, being women, with respect to the Constitution, is how do we put it back to Section 217 and its intention? That is the area, Chair, that becomes very critical, that we thought maybe as we're having this discussion, that we keep that at the back of our mind. We have an opportunity now to correct and go back to what the Constitution required when it was. Thank you, Chair.
Thank you so much, Ms. Peterson. Is there anyone that will still want to come? You spoke about 2 names.
Thank you, Chair. I'm not sure if my colleague, Mr. Matibula, would like to join, but maybe I could also just quickly, Chair, apologies, just on the issue of local content, that one of the committee, Honourable Governor, mentioned about the local content. I think that has been, there was an opportunity for institutions to really utilize this from 2011, but unfortunately, I think sometimes issues around compliance go beyond just policy and legislation, but it's now, you know, where there's no consequences maybe for non-compliance, or else there isn't proper governance frameworks that are put in place to maybe ensure that this happens. But now again, as we were indicating, because this will now be an issue that will be linked to institutional strategic objectives and their own policies, it will be an opportunity now for institutions to bring that in as part of perhaps their RDP goals. But also, I think the DTIC, because it's a policy that is administered and the mandate sits with them, they've also been doing a lot of training sessions around this issue to try and assist, because I think what happens sometimes, institutions maybe get, and the supply chain framework is overburdened with so many forms and things that institutions sometimes get overwhelmed. So they have been doing training around that to try and assist, you know, institutions to understand better. But yeah, so I think that just, but on that, I think obviously now that the dispensation is changing, albeit maybe temporarily, until we see what the bill talks to, it would probably then be an issue where there'll need to be a lot of lobbying and advocacy, you know, and particularly by the DTI amongst institutions. Thanks, Chair and colleagues.
Thank you so much. But CPO, I thought you were going to share that circular to us as well, so that we can just read it clearly in black and white, because for now it's just a matter of assumption that the intentions of the minister, because the reality that what also caused a panic button was the media briefing by the DG, Mr. Dondo. I thought because the problem, you might misconstrue some of the things. If the DG is emphatic on certain elements, that becomes a compelling reason for others not to spend. As you know, that after the president has spoken, that becomes the police. At this point in time, we were clinical that the role that is played at the administration level now of National Treasury is critical. So everything should be clear so that there are no contradictions in the process. If then there is no one who wants to come up, then we could just give our Deputy Chair of Chairs, Honorable Manzini, just to do the honors on our behalf and thank everyone who's in the platform. So let me ascertain, honorable members, there is no follow-up questions. Members were clearly covered.
Yes, Chair.
Chair, thank you.
You are? Okay. No, great stuff. If there's a hand, it was, well, that was your hand, so you are covered.
Yes, Chair, I am, thanks.
Oh, great stuff. In that way, Honorable Manzini, please do the honors for us, because that will be part of our way forward. We've already mentioned that we might hope that we'll partake and participate. Honorable Sonjika has already mentioned that the Secretary must organize the legal gurus on our side so that we consolidate our approach as well as the legislature is playing the oversight role, so that we are not bystanders, but we partake in this journey. By the next time we meet, we hope this thing will be sorted for our benefit, not against us. Honorable Zongo.
Thank you, Chair. Firstly, let me show my face. I think I'm also appearing on your side, and I would like to close after I've done so. Greetings, and let me thank this opportunity that has been afforded to me by the chair of committees to thank all the people that have just joined, in particular the chair of appropriations, Honorable Ubuthelezi, because I believe, having been him who agreed to the call that was made by the Honorable Chair of Committees, maybe wouldn't have got this opportunity. Also thank all the attendees, in particular Babu Klaba, Honorable Klaba, Cyril, who's also had a bite in sharing that which was shared by the Honorable Ubuthelezi in line with the bill having to be clearly outlined so that it becomes user-friendly to be understood or be understood by each and every individual, including the laymen or the ones that are not well familiar with these legal terms that are normally used in our bills and the legislative framework that we use when we do or execute our work. The presentation, Chair, that was done, I think it's also assist us as the province of KwaZulu-Natal, because we are the ones that might be suffering, as Honorable Umanchinga has indicated, that we might find the resistance in terms of ensuring that we do serve our people by the fact that this provision has been made not to be interpreted the way it is supposed to be interpreted. So I believe that this platform of this engagement has opened our eyes. You have also said that we are going to make submissions, as Honorable Sonjika has advised or requested, which we all do believe that it's going to assist us moving forward. Chair, I might not be doing justice if I'm not also thanking all the attendees, the whip, our chief whip who is present. We note the apology by the MEC Unube, but also the presentation that was done by the National Department. The information, I think it's worth empowering us and is going to assist us moving forward. Those will be the words that I would like to share, and thank you very much as the chair of committees for seeing the opportunity as empowering and wanted to share with us so that we are all enlightened in terms of the developments regarding the matter, which is affecting not only us as the department, but our people, because those are the ones that suffer when there are laws that are promulgated that seek to regress or make us regress from what we used to have as the government of the day. Thank you, Chair.
Thank you so much, Kwabene Nyamagaishi. Honorable Manzina, our Deputy Chair of Chairs, is the one who suggested that this thing must be streamlined live so that others are able to encapsulate the spirit. So we want to thank you profusely for that delicacy and for that advancement. Indeed, it has yielded a positive and a critical mileage for this legislature. Let me just thank the entire participant. We want to close the meeting on this positive note for today. Be blessed. Let's meet next time there is a progress. The meeting is officially closed.
Tombe.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Chair.
Thank you, Chair.